Hi, everyone joining. We're just going to give it a few minutes because we are before the 1 o'clock hour, but we'll get started shortly. Thank you. Hi, everyone that's joined. We're just going to give it a few more minutes to get right at the 1 o'clock hour, and then we'll get started. Thank you. Okay, everyone, thanks for joining. This is our third year of planning the Today for Tomorrow series. Financial wellness is one of our four pillars of well-being, and in addition to investing in your future, it includes planning for when you're no longer here and helping partners, spouses, or other parents, loved ones into planning for the future. Today is part two of our Everything You Need Plan webinar. Our speaker, Daniel Timins, joins us from Zimmett Law Firm. And Daniel, also in addition to today, there's a handout attached if you see in the toolbar that you can click for the deck that Daniel will be speaking about. As always, we'll take questions at the end, so we'll go ahead and open that up when Daniel's finished, and you can go ahead and type them into the chat box. And with that, Daniel, I think we're ready to go. I'll turn it over to you.
Thanks, Kelly. And for those of you who missed last week, wow, you missed a great webinar. But either way, this week has kind of progressed a little bit. Frankly, this is about other people's money as opposed to perhaps your money, meaning that someone perhaps has passed away or you're planning for if you pass away. I just wanted to say that your insurance plan that you have for legal insurance is covering estate planning, simple estate planning documents with Zimmett Law Group. So you can feel free, of course, to contact us if you have any questions if you're in the New York and New Jersey area. So without further ado, I'm going to begin talking about other people's money today and how that works, or your money when you do pass away or if you're incapacitated, in Trusts and Estates Part 2, Wills, Trusts, and Estates. So the important thing to remember is that some of these things apply to you, some of them do not. There is a lot of topics that we will cover and a lot of subject matter. I don't expect you to remember it all, but the important part is this. If you come across something you say, that applies to me, make a note of it. If you have one of these things where you say, oh, I should change that, just write on your piece of paper, I should change this. So you may want to have a piece of paper available just to do that. But that being said, just because we discuss it doesn't mean it actually is the case for you. So that is my disclaimer. Some things apply to you, some things don't. What are we talking about today? Guess what we're talking about? Money. Of course we're talking about money. And the idea today is that we're discussing how to minimize taxes, any court fees associated with money passing within your family, and any attorney costs. Yes, attorneys get paid, but you can pay them less up front than trying to fix a problem at the back end. This is about maintaining control of assets during your life and taking steps to minimize estate nightmares. That comes very last. We will be covering the topics in the following orders. First will be transfers of property outside of your will, then retirement plans in your estate, wills and probate, using trust correctly, and lastly, avoiding unforeseen problems. All of these are topics within themselves that can be rather expansive, so let's just be very general for the time being. Let's again look at the difference between income and assets. You know, we're not really much in control of our income. Yeah, I suppose we could work harder and get a bigger bonus, etc. But, you know, especially when we retire, income just kind of typically comes in the form of Social Security. If you're one of those people that has a pension or your spouse does, congratulations. You're good as gold. But the truth is, when you pass away, there's only one person you can, and again, it's only sometimes, leave your money to, and that is your spouse. So today isn't really about planning for income because, frankly, there's not really a lot of planning. The only planning you have is what age do you want to take Social Security at? This is about the stuff that you own right now, your assets, the stuff that you have complete control over. I can give my money to anybody I want. I can spend it. I can buy Bitcoin or Litecoin or, you know, any type of investment if I want to. I can invest in just a heap of gold or even wood. We can trade or give our existing stuff to other people. I suppose we can assign income, but it's not really easy. You know, we're used to just giving a dollar bill, not signing a contract and saying, I'll give you a dollar bill in the next few weeks. We're talking about assets today and transferring assets, what you own, not income, the stuff you have on an ongoing basis. Now let's talk about what your gross estate is. This is everything you own when you die. So that includes non-probate assets, meaning assets that do not transfer under your will, and probate assets. You will see we transfer property in two different ways. One way is called non-probate, also known as an operation of law transfer. That means it just kind of happens as a matter of law. We know who receives this money when you die. You'll see what I mean in a few moments. We also call these testamentary substitutes in my world because they are substitutes for things that pass by your last will and testament. That's why it's a testamentary substitute. And then there is your probate estate. Probate is a process that transfers property under your will. If we do not know who gets an account the moment you pass away, so it is not an operation of law asset, we don't know who gets it. You'll see what I mean from that as well. But the idea is, how do we know who gets it? Well, we have to look at your will to figure out that property and who receives it. So let's start first and foremost, what are transfers outside of your will? These are called operation of law. The moment you die or your family member dies, we know who the beneficiary is. We know who's going to receive it. The only thing that needs to happen is that that beneficiary needs to produce a death certificate for you, or someone else does, and then the financial institution says, well, sorry, unfavored son, this is actually going to favored son. Do you know where we can find him? So if unfavored son shows up with a death certificate, you know, he just helped out his childhood nemesis, his older brother. These are the different types of assets that transfer when you die, the moment after you pass away. Your life insurance has a beneficiary designation. Your 401k plan, or if you have an IRA, you've named the beneficiary on that. There's no need to probate it. If I say in my will, I leave everything to, I don't know, the Hump Water Buffalo charity, but my 401k plan says to my wife, Michelle is receiving it. It's not transferring by my will. Any joint property, if I pass away, my wife in tears will show up at the bank with our joint bank account, and she'll show my death certificate, and then she'll see how much money is in it, and then she'll really cry. She doesn't need to go through probate to receive joint property, just needs that death certificate, and the bank will give her the money. Same thing with your house, or if you have brokerage accounts. If you have an account that's solely in your name and you only have one beneficiary, like here's an example, if you and your spouse have some separate accounts, in my case, so that my wife doesn't know how little I spend on her stuff, in her case, how much she's spending on stuff she gives to me, we can just create a transfer on death account, which means during my life, the Daniel Timins checking account has Daniel Timins as the sole person who can access it. But it says transfer on death Michelle Timins. So when I die, she shows up with the death certificate and she doesn't need to go through probate. And then also trusts are will substitutes. They do not pass by probate. And last but not least, prenuptial agreements, postnuptial agreements, partnership agreements, etc. Those are contracts that can supersede a will. And again, they transfer outside of probate. So really quickly going through each of these, I think you know them. So just in the hope of saving some time, I'm going to go through them relatively quickly. For jointly owned property, it can be for life insurance, it can be for bank accounts, it can be for homeowners, etc. It's very easy to transfer this when you die. The person just shows up with a death certificate. In the case of a bank account, I just have to show up, period, and take the money out because I was already an account holder on the account. I don't need to prove to the bank anything. I can take out every penny. If, however, there's something like real estate, I'm going to need to go to the county clerk and say, okay, my wife passed away. Here's the death certificate. Now the deed should be changed to just me, not me and my wife. The negatives of joint property is that if you have someone that you don't trust who's a joint owner, they can take all the money out. And that kind of stinks, clearly. So, you figured, well, I trust my son to do the right thing. I know I beat on guys a lot during our conversations. What can I say? I tend to see guys do a little bit more than women, but women, you're not immune to doing bad things either. But the truth of the matter is this: if son says, hey, thanks, mom, I'm going to be taking all that money now out of our joint account, well, mom's kind of stuck. There may also be gift tax consequences. That's not going to be something we'll talk about much, just because that's a pretty high amount that needs to be transferred. Life insurance, these are the three parties. There's the insured individual. If I die, this policy pays out to someone. That means I am the insured. There is the owner of the policy. The owner gets to choose who the beneficiary is. So if I own my life insurance policy, I can say, you know what, this goes to my wife, not to my mom. Or my wife can say, you know what, it doesn't go to my husband, it goes to my parents if I die, if she's the owner of her policy. Or if she's the owner of my policy, she can choose whoever she wants to be the beneficiary. Again, all that needs to happen is the beneficiary needs to show up with the death certificate of the insured, no probate. Retirement plans, we have a slightly longer discussion regarding retirement plans, so I kind of skipped forward here a little bit. And I want you to hang on here because we're talking retirement plans and the effects when you pass away. This isn't important just for you, but it's important for your parents who may have IRAs. A lot of you who are on this webinar have parents who were in that first generation who could take advantage of things like 401ks and IRAs, etc. And you may say, hey, that was me, and I apologize. Don't worry, you're not old in my world. You got to be 90 years old for me to allow you to call yourself old. So if you're 80 and you started up in the early 70s to start a 401k plan, all the more credit to you, you're still not old. Okay, the beneficiary needs to be named on the beneficiary designation form for the retirement plan. If they show up with a death certificate and someone else is the beneficiary, it doesn't do them any good. It does the named beneficiary on the plan good. So something I recommend, and this is one of those, let me just check on it, make sure you know who your primary beneficiary is and your contingent beneficiary. If you and that primary beneficiary, if something happens to you, a car crash or something, want everybody to do that before the end of the year. Look at your beneficiary designation forms for your employer retirement plan, as well as any other IRAs you may have from a former employer. Now you have to begin taking required minimum distributions at 70.5. Remember, when you have a 401k plan, you're not actually paying any income on that money. You don't have to pay any income tax, excuse me. That's a great benefit. I don't have to pay tax now, and I'm working now, so I'm earning more income now than I probably ever will when I'm retired, because then I'm not earning income. So the benefit is that you don't pay taxes now. The downside is the IRS says, all right, we're giving you a break. You're going to have to pay taxes later. You knew that was going to happen. You take required minimum distributions the year in which you turn 70.5. Just met with someone yesterday. His birthday was a few days ago. I said, congratulations, you have to take out required minimum distributions the year you turn 71, because at 70.5, he's in the next year. He's after October, six months plus that. So I said, you could be 71. He's happy. This is called the required begin date, which is typically the year after you have to take required minimum distributions. This shows you how much of a percentage of all of your retirement plans you have to withdraw. I want you to commit this to memory. This will be the thing that there will be a test on later. Thank you for doing that for me, Kelly. No, let's go over an example. At age 70, the first year I have to conceivably take out required minimum distributions. I have to take out 3.65% of all of my account balances. So if I have $100,000 saved in my 401k plan and I retire at age 70, I have to take out $3,650. Excuse me. Forgot to round the one. Because that's 3.65% of my total retirement plan balance. You say, well, what if I have 3 retirement plans? You have to take out, not necessarily from each account, but you look at them all, you total them up, and then you have to take out this percentage. Let's look randomly let's look at the bottom at age 89. It's not unusual for me to meet with 89-year-olds. Like I said, you're not old until you're 90. At age 89, you have to take out 8.33%. So that $100,000, you now have to take out $8,330 of your IRA for a required minimum distribution. That's the minimum you can take out. You can take out a heck of a lot more. You can take it all out. But remember, you're paying income taxes on this. What I want you to see is that this starts going up exponentially. So between 70 and 71, it goes up only about 0.12%, not a lot. But if you look at between age 90 and 91, now you went up almost 0.5%. So the percentages start to increase. By the time you reach age 115, you have to take out a little over 50% of your account. At that point, I don't even know if you know what's going on with money anyway. Now, if you pass away, your spouse's required minimum distribution is the same as yours in this way. Your spouse can transfer your IRA to her or his name. Let me repeat that. My wife is 4 years younger than me. If I pass away, we can see from the prior slide that if I pass away, let's say I pass away when I'm 90, I have to take out 8.77%. She transfers it to her name, and she only has to take out 7.09% because she would be 86 at that time. That's the big benefit that we have with the spousal distribution. They can contribute to their own IRA, and when you die, they can transfer your IRA to them. That's only with spouses. If you leave your IRA or your 401k to your daughter, she cannot put that IRA money into her IRA. I'll explain the significance of that in just a moment. But the important thing to remember is that if you love and trust your spouse, your IRA is probably a good asset to leave to them as the sole initial beneficiary. If they die first, then leave it to the kids. But the idea is that your spouse gets preferential treatment because they can put it in their own IRA. Well, what about somebody else? I'm divorced, or I never had a spouse, but I have a kid, or I have a nephew that I really love, whatever the case. You're leaving it to someone other than a spouse. The law is going to say, do you have a designated beneficiary? Many entities, it says, can be a beneficiary, like a charity, a corporation, an estate. They are a beneficiary, but they are not a designated beneficiary. A designated beneficiary must have a life expectancy. It's got to be a person, okay? So Joan Rivers, she actually had a life expectancy. You would have never known it when you saw her. But the point is this. They must have a life expectancy or else they are not considered for legal terms a designated beneficiary. Here's the point. If I name even one beneficiary as a non-designated beneficiary, then none of the beneficiaries are. So if I leave 99% of my money to my daughter and then 1% to charity, it ruins the retirement plan as far as distributions go. I'm going to just try to keep this simple. Your beneficiaries have to take required minimum distributions, even if they are under 70 and a half. If you leave your IRA to your 7-year-old grandson, he has to take required minimum distributions. Now, the percentage is very low, and that's what these next two slides show, and I'm not going to spend too much time talking about it. they're kind of self-explanatory. When you sit down, you really crunch it out. The problem is this: if there is no designated beneficiary, or if there's required minimum distributions, the issue is going to be this: that yes, the owner can take out for their life expectancy, but then your children take out for their life expectancy only if they received it after you were 70 and a half. I wish I had more time to explain these slides, but I'm just kind of rushing through it. Just remember, with non-spouses, this is what the IRA will look like. The account was named the Daniel Timins Inherited Retirement Account. Or not inherited, excuse me, individual retirement account, my bad. Now it's named the Daniel Timins Inherited IRA for my cousin, Tim Daniels. That's very different than the Tim Daniels IRA. You know, Michelle Timins can take the Daniel Timins IRA and turn it into the Michelle Timins IRA. But here, my nephew, Tim Daniels, has to take it as the Daniel Timins Inherited IRA for the benefit of Tim Daniels. It looks very different. It's not the same. And they have to take required minimum distributions no matter how old they are. It's not an IRA, it's an inherited IRA. In addition, my IRA, this is something to put in your hat. Your IRA is protected from all creditors except the IRS and your spouse when you're getting divorced. The state in which you live in cannot place a lien against your IRA. Your creditors, such as your credit card, or your mortgage company that you defaulted on, they can't take money from your IRA. Your IRA and your 401k are protected from all creditors except the IRS and your spouse. However, when you leave your IRA to someone other than your spouse, it becomes an inherited IRA. It's not protected by creditors. So I want you to remember that. I'll speak quickly about transfer on death accounts. If you have that bank account, like I was saying, in your name, and you say, well, I want to maintain access to it while I'm alive, but I only have one child. I don't want them to be a joint account holder. But when I die, I don't want them to have to go through probate. You can change it to transfer on death. It doesn't have to be a child. It could be a niece. It could be a trust that you create. It could be a charity. The idea is while you're alive, it's yours. For checking accounts, it's called in trust for. For brokerage accounts, stocks, it's called transfer on death. That's the big difference. Next, for people who own real estate, you know, when I die, if I die and my spouse has already died, or I'm not married or never been married, and I'm the sole owner, that's a part of my probate estate. Well, if I have real estate, that's a pain in the neck because now no one's paying the bills after I die. You have to get the will permitted to by the surrogate's court into probate. So the house is just kind of sitting there for weeks or months because I got news for you. Courts don't necessarily move very fast unless it's not in your best interest. So you can create what's called a life estate. You can change the deed and say, I want to live here the rest of my life. And when I die, it gets transferred to my choice of beneficiary. Say, well, how does this apply to me? If you have aging parents and you're one child of few, or if they want to disinherit a child, or if they want all of you to receive it and they want it to be sold quickly, maybe they should change their deed to a life estate. They retain a life estate to live there the rest of their lives, and then when they die, they leave it to you outside of probate. So if you still have a parent who's alive or parents, you may want to talk to them about creating a life estate. You will save money on having to pay attorney and court fees when they die, when otherwise you would have to go through probate. So why wouldn't you leave all of your money as a joint tenant to someone or transfer on death, etc.? Well, there's several. When I create a trust, I can create creditor protections. When I have a beneficiary who has substance abuse problems, I can create substance abuse provisions that will say, don't distribute it to the beneficiary. I don't want these funds going to his drug dealer. When you leave funds directly using life insurance or a transfer on death account, you can't choose when a person receives it. So for example, if I name my minor nephew as a transfer on death beneficiary on my bank account and I die, he's a minor. Minors can't own money. If it seems strange that, hey, I received a $2 million life insurance policy when I was 13 years old, if that just doesn't seem right, you're right. It's not right. Minors can't own money. Next, you can't choose how a person receives that money. So if you want a family member to hold on to a certain piece of property, they can get rid of that property. And next, it can ruin a disabled family member's benefits. If you have a disabled family member and something happens and you leave them money when you die, you can knock them off of Medicaid or supplemental security income, basically Social Security for disabled poor individuals who haven't worked a lot. In other words, if you give money directly to people, you give up control, and sometimes the beneficiary is his or her worst enemy. So then we can use something instead called living trusts. Now, living trusts very simply are this. A living trust is like a will. It's a will substitute. So in other words, whereas I would leave money to someone as a joint account holder or transfer on death, but I just don't trust them to do anything, instead what you use is a living trust, which is a will substitute. It does transfer property outside of probate, so it's still operation of law, but you can control the assets. So unlike leaving something like a life insurance policy directly to, your wayward daughter, now instead you can leave it in trust and make someone else the trustee. And that way she doesn't spend all the money or the creditors can't get at it. Remember, with a living trust, it's a separate document from a will. There's no court oversight. That's right. When you die, a revocable or a living trust does not have to go to the courts. Now, one that's created during your life is called a living trust. Surprise, surprise. One that's created by your will when you die is called a testamentary trust. It's created by your last will and testament. So it's not around when you're alive. It's only around when you die. Which brings us to wills and probate. Now, this is the process that we have to discuss when we look at probate. Is probate the worst thing on the planet? No. Is it something that's desirable? Typically, no. Probate is a legal process where a court oversees the appointment of your legal representative, your executor, the person who does the job, who represents your estate as if they were you. They step into your shoes. They collect the assets that you still own that weren't transferred by operation of law, so they can pay off your estate's creditors. They can bring lawsuits or defend lawsuits. They can ask for any of your protected healthcare information for medical malpractice actions. And they can pay any remaining money to beneficiaries that you have named in your will. That is what probate is. It is a court process. Now, some people say, well, I have this leftover house and I never created a will because I really don't know who I want to be my executor or who I want to leave stuff to. So I'm just going to wait till I die. Boom. And then you die. Well, guess what? You wouldn't be the first person to die without a will. In this case, this is New York's, I guess you call it statutory scheme. It's not a scheme or a scam. It's just this is the schematic that is used. And it's not that different from other states. If you have a spouse and you die without a will, your spouse receives all the property. That's great. Well, let's say you have a spouse and kids. If you don't have a will, that spouse receives $50,000 off the top, and then they split the rest of the property 50-50 with the kids. So sometimes I'll have a couple come in here and I say that, and the healthier or younger spouse says, oh, no, 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 no. I want everything to go to me. I say, well, then you better tell your spouse that they better create a will right now. If you have no spouse when you die, everything goes to your children. And then if your children predeceased, it goes to your grandchildren. If you have none of these people, if you only have parents, which everyone has parents, receive 100%. If you have no parents, no spouse, children, etc., it goes to your siblings, and then in their absence, nieces and nephews. So you see, this is how intestacy, meaning dying without a will, which is testate. When you die without a will, intestate, these are the people that receive the property. So I want you to place yourself in here in this list of people and figure out where your estate goes if you have no will. Now, this priority is important because these are the people that are denied if you have no will. If you have a life partner, most states don't have common law marriage. People say, well, I've been with them for 20 years. Hey, I'm in New York, New Jersey, Connecticut, no common law marriage. All right. So people just, if you're worried about, your daughter's choice of boyfriends, as long as they don't get married, you're cool. Don't worry about it. Because life partners, when you die, if she dies, don't worry, he's getting none of it. But the problem is if you have a life partner and you haven't created a will, they're getting nothing. Doesn't matter how long you've been together. Your friends get nothing without a will. Those people who are not in the line of succession I just showed you, including stepchildren, get nothing. I have a stepfather. I'm close with him. We've been together for over 30 years. If he doesn't create a will, everything goes to my stepbrother. He's an okay guy, but I don't love him that much. Pets get nothing. Organizations and institutions, your church, your charity, get nothing if you have no will. Business partners get nothing. And if you want to leave specific gifts to specific people, guess what? You had that chance when you made a will. You didn't make a will, though, so now it all gets split up. The ring gets sold, and it gets distributed equally. So then, what is actually transferred by our will? Wills, remember, only transfer property you still own after you die. My life insurance policy already gone to my favorite nephew. My retirement plan already went to my wife. My transfer on death bank account gave it to the Humpwater Buffalo Charity of America. There you go. Well, I still have a bank account. I still have my stuff. I may have real estate that's still in my name. So basically, a will only transfers stuff that's still in my name moments after I die. We don't know who gets it. That is what is called your probate estate, or my estate, because we don't know who gets it, so we have to look at the will to figure out who's going to receive this property. Here's my big note. If you check those beneficiary designation forms that transfer outside of probate and by operation of law, you are never, never, ever, never, ever, never, never, never going to name my estate as the beneficiary. All right? Because you're taking a non-probate asset and you're turning it into a probate asset. People will name their estate as a beneficiary because they think they're making some sophisticated or erudite decision. No, you're making a fool of yourself. Don't do it, because now you have to pay court fees and attorneys to transfer money you otherwise didn't need to transfer money to using probate. Bad idea. This is important. What is a will? It's an original written or typed legal document. Your will doesn't have to be typed. It can be written. I suggest to you it should be typed. Signed by you and witnessed by disinterested people. If you're leaving everything to your two kids, they better not be the witnesses on your will, because then you have a problem. It states who received what assets that are still remaining when you die. Names a legal representative, like we said, named your executor, who deals with your final affairs. Plus, you can name a preferred guardian for your minor children if you have any. It's submitted to the court. In New York, it's called the surrogate's court, because it steps into your shoes, you're dead, so it becomes a surrogate that oversees the probate process at the time of your death. But your will is only probated if money or guardianship needs to be dealt with by it. If all of my property transfers by operation of law and there's no money left in my name, because I left everything as transfer on death or life insurance or retirement plans and joint property all to my spouse, then my will doesn't get probated. There's no reason to probate that will. So it just kind of sits there and disappears. I want people to remember that. Now remember, if you have a will, it's called probate. If you have no will, it's called administration. The legal party who's responsible is called the executor under your will. For administration, it's called an administrator. In your will, you can decide who gets what. Under administration or intestacy, it's what the state says. We already went over that. You cannot disinherit your spouse entirely, by the way. Your spouse is only entitled to a third in New York. It varies state by state. I'm just using New York because it's convenient to always go back to New York, since that's where I am. You couldn't tell from the traffic and the honking. That's New York for you. Now, who is required? Well, if you have a spouse, your spouse is required to actually be placed on notice that your will is being probated. If you have a spouse and kids, your spouse and kids have to be placed on notice. Doesn't mean that you left everything to your spouse. Your kids still have to say, hey, I don't have a problem with mom getting the rest of dad's money. What if your spouse is no longer with us, or you never had a spouse? Then it goes to your children, and they have to get placed on notice. Remember, you don't have to leave anything to these kids, but they are getting placed on notice. And if you look at this list of people, you say, hey, this looks familiar. Yep, these are the same people that receive your estate if you have no will. The state says this: since we haven't proven this will to be effective yet, you are the people who have the right to overturn it. Now, they typically don't. You know, it's hard to win an estate case against your will. It's possible. There's often a lot of settlements. I have news for you. The legal system is not big on actually trying cases. But these are the people that must be placed on notice. So if you leave everything to your spouse and you have 3 kids and 1 kid in particular you're not happy with, doesn't matter. If you die, your spouse and your 3 children all have to agree to that will, or they can fight it. Now, in that case, let's say I leave everything to my children. And then my brother says, well, hey, I was entitled to some of this money too. I'm going to fight the will. He doesn't have a right because you see, your kids come before him in the line of priority. If you have children or a child, your parents, your siblings, your grandparents, your aunts and uncles, cousins, etc., they have no right to contest. Now, I do occasionally, on rare occasion, have people who have no cousins, or they've been, they just don't have any cousins. The state receives their money if they have no will, number one. And number two, the state has to get placed on notice if you leave money to anybody and you have no one closer than cousins. That's an important thing to remember as well, if you have a small family. That list of people is interesting because it determines who gets your money if there is no will, like we went over before. States who gets placed on notice if there is a will. Just because I didn't leave something to 2 of my kids and I left it to 2 other children doesn't mean those 2 I left out don't get a copy of the will. Yep, they get a copy of the will. So it's in your face, Timmy and Margaret, because I didn't like you, so now you get a copy of the will. You could see how much I didn't like you. It also says the priority and who can be named as the executor or administrator of your estate. You can name your executor. Remember, you can't name your administrator because you never wrote a will for administration. So it's just your closest family member who chooses to do it. And it also states who can legally contest your will. Timmy and Margaret can contest my will if I cut them out of my will because they're my kids, 2 of the 4. I don't actually have kids named Timmy and Margaret. It would be pretty bad to name some kid Tim Timins or Timmy Timins. Anyhow, what does the court do? Well, the court approves or disapproves of your choice of executor. When you die, you give the will, not you personally, your executor, your attorney, somebody drops the will off at the court, and they'll say, yep, we agree with your choice. You named a good executor. If your executor happens to be a felon or, there was some wrongdoing, they may say, no, we don't like this choice. They may require the executor to account for their actions because the executor is in control of your money when you're deceased. They're doing what you want them to do with it, but they're the ones that can write out the checks. Now remember, a will is in public until you die and it's submitted to the court. So if you've written a will already, you're cool, don't worry, no one can look at that just yet. But when you die, it has to get submitted to the court for it to be valid and to be probated. And this is important. The court only probates original wills. Photocopies that you have need to be proven valid, meaning you have to find the drafting attorney who could be dead. You need to find both witnesses to the will who could be dead. And then you got to cross your fingers that the judge is having a good day. You need that original will. If you left your original will with your attorney, you may have made a mistake. I hold on to a handful of wills for people who they're scared if they die, they have no one else who's going to know where to find it. If you have a file cabinet at home, I guarantee you, if something happens to you, your family members are going to look through that file cabinet because they're looking for stuff. Keep your original will. Don't let your attorney hold on to it unless you really don't have anyone else you trust to hold on to it, including yourself. You'll excuse the siren in the background. That's just New York for you. What does my executor do? An executor steps into your shoes. They do everything that you can do. They collect your assets that transfer through probate. They can pay for funeral expenses or get repaid or pay back the people that paid for them. Pays creditors and taxes of your estate. They can hire help. Executors hire people like me and accountants all the time. Movers, move stuff out of the house. I'm not going to require your executor to have to move your property. Your executor may be your spouse. Your spouse may be 89 years old at that point. They can get the testators, meaning your deceased medical records, so they can bring a wrongful death lawsuit. They can bring a lawsuit. Other types of lawsuits. They can clean out your closet, and then they give everything else to the beneficiaries. These are all the things your executor can do. They can enter into contracts. They can do everything that you could do. They become your legal representative. Now, Let's say you have a small estate that's passing through probate because you did the right thing. You transferred most of your property through operation of law. You named the beneficiary on your retirement plan and life insurance. You had your bank accounts transferred to someone under a transfer on death account. But now you have a little bit of money left over. Well, who gets paid back first? Number one is the funeral home, because you see attorneys and accountants and court fees are number two. Even we don't want to deal with the body, but you knew we were going to write ourselves in there somewhere in the law pretty high up there. The funeral home gets paid back first. So if you have a $10,000 estate and there are $12,000 in funeral costs, all the money goes to the funeral home. Then there are attorneys and accountants. Yep, you knew we were going to get paid. Then your executor receives a fee. I think I put that in here as well. It varies state by state, but they're the next people in line to get paid. Then there are preferred creditors, things like taxes or your mortgage on your real estate. So you see, you can already pay for your burial, and then your professional helpers, and then your executor, at least a little bit, before any of these other creditors get paid. After that, non-preferred creditors like credit card companies get paid. And then once you've paid all these other expenses and people, then the beneficiaries get money. So you can't say, well, I leave money to my beneficiaries, but not my creditors in your will. You can't do that. That's what a probate estate is for. I can tell you, you can make it very difficult for your creditors to get that money if you leave it as operation of law, meaning it doesn't go through probate. Guess I can't really tell you don't pay your creditors, but life insurance you can leave, and it goes to your beneficiaries. They don't have to pay your creditors. You may want to pay for your own funeral expenses. I'm just putting that out there, because otherwise your family's going to do it, and they're going to wait 3 years before they give you a headstone, and then it's going to be cruddy. Now, your will states your choice of your children's guardian. Remember, your choice of guardian is only one in 13 factors that a court looks at when they're determining who's the best guardian for your kid. So this is for a minor child, not people, my mom says, I feel like even though I'm in my 40s, I feel like I became an adult just a few weeks ago. I don't know, every time I pay taxes, I feel like an adult. But whatever the case is, this is only for your minor children. The court looks at 13 factors. It says, what location is the child in? Is the proposed guardian a good choice of guardian? Et cetera, et cetera. What's in the best interest of the child is the most important thing. The court will ask 13 factors. Your choice is a big one, but you can't really measure how much of it is. You should still place it in your will. Facts about wills. Your will is valid in every state of the United States and in most foreign countries. We have reciprocal treaties with places like Italy and Israel and Taiwan and where are some of the other places? I mean, I can name probably about 20 countries that I've gotten to do probates with English wills, American wills, I should say, and then several countries where their wills were made in that country and then we probated it here as well. If you use your U.S. will to transfer foreign property, you may need a court-certified copy here to give to that foreign country. If you use a non-U.S. will, you may need to have it translated. But you're all here in the United States, or at least most of you are on this webcast. Make your will here in the United States if you have a foreign will. It might be a good idea. Facts about wills. You want to get gifts in writing. Wills are important. So this is what I mean. I always have this happen. Well, Grandma said she was going to give me her, $10,000 diamond ring when she died, and then the will said it goes to my niece. Or I was supposed to get the cherry red Ferrari, and now it's nowhere to be found in the will or anything, and I don't have the title in my name, even though your uncle told you that. So now everyone gets to split the Ferrari. The important thing is this: you need to get these things in writing. If you want to leave something to someone and you just tell them, it doesn't do them any good. It has to be in the will, because there is no dead man's rule in New York. What someone said who is now dead, if it benefits you, you can't use it in court. Now, you could try to blurt it out during a deposition, but the court's going to say, we don't care, because this person had the right to put it in their will and they did it. So when someone says they're going to give you something, remember, you're just going to say, I want you to put that in writing, please, and make it in a will, because a handwritten letter doesn't go very far either. It's got to be in the will. Which brings us to trusts. What are trusts? Trusts are written and signed legal documents that that have a creating, administering, and beneficial party or parties. They state the terms that the assets that are held by the document shall be administered to. It avoids court oversight. When you die, a trust is completely outside of the court's purview. It continues to exist after your passing for as long as you state you want it to. And it only impacts property that's owned by the trust. Those are all important points. Here's examples of different types of trusts. So here, if I have, and I got news for you, I got this type of service for free. I just do it myself, so it's cheap. The Daniel Timins Revocable Trust, or I could call it the Daniel Timins Living Trust. It's different than the 123 Rebecca Irrevocable Trust, but they're all trusts. These are names of trusts. When you hear, like at the end of Batman Begins, when they say, Bruce, how did you buy back the company? He says, well, I had a bunch of trusts, 123 Rebecca Trust, who the heck is that? Who knows? I know because I helped draft that trust, but the point is this, that this is the name of another trust, and some of the things that can be done to help with that. Now, trusts, who are the parties? There's the creating party known as the creator. They create the trust with someone like me and they fund it. They say, let's put this property and have it owned by the trust. Not all of your property is necessarily owned by a trust. The trustee manages the property. They pay off the taxes. They file the income tax return with the help of an accountant. They invest the money. They do receive a commission. And then the beneficiary just kind of kicks back and receives all the money. So you have someone who creates the document and gives it money. You have someone who administers to the property under the document's terms, and then the person just kind of sits back and gets the money. So these are some, oh, what a morbid slide. I really made it gray. Too bad this one should pop out a little bit more. Well, wills are public. Probate is public. Trust administration, private. Wills, burden of proof is on the executor. Your executor has to do a lot to prove this will to be valid. Trusts, easy. The burden is on the contesting party. So if I disinherit someone, I'm going to be using a trust. If I want to avoid publicity, I'm going to be using a trust. Using a will is slow because, surprise, surprise, the court's involved. Plus, you have to pay someone like me, surprise, surprise. Who do you think's getting paid more, the court or the attorney? I get paid pretty well with wills and probate. Now, trusts, it's fast and it's minimal administrative costs. Your body can still be warm. I just need a death certificate and I can begin helping family members transfer money from your name or your parents' name to the next beneficiary. Now, the benefit of a will is it doesn't take a lot of mental capacity. The person who kind of knows who they are and kind of has an understanding of their property and their family members, that's good enough. It's not a high level of capacity to execute a will. Trust is a little bit higher. So if you get someone who has severe dementia, they're probably not going to be able to create a trust. Now, a will just needs to be executed to be effective. Whereas a trust, like I was saying, it needs to be funded, which we will cover in a few moments. I can have a trust that is around during my life that I can revoke. It's called a revocable trust. It's continuity of finances. When I die, there's no probate. Trust keeps going. Afterlife, there's no probate fees. It's a faster distribution. There's some flexibility regarding the terms of when I can distribute money. These are the parties. You create the trust, you are the trustee, and you are the beneficiary. Yep, this is just like your life. You create money, you administer and invest it for your benefit while you're alive. Well, the trust is the same. Plus, it's avoiding probate. Plus, if you're incapacitated because you get a stroke, then you name your spouse or your kid or your nephew or your best friend to be trustee and continues to manage the money for your benefit. Just because you're no longer the trustee doesn't mean you're not the beneficiary. So trusts are good. Good, good, good. Those are revocable trusts. Those are trusts that you can change. What about irrevocable trusts? Well, we touched upon this last time. There's only 3 reasons. I wrote a great article. I'll pat myself on the back. God knows that, I do that with some frequency, but here, this one actually deserved a pat on the back. There are only 3 times you want an irrevocable trust. Number one is to provide you with creditor protection. Your revocable trust does not have creditor protection because you have complete control over it. If you want to reduce your estate taxes, you need to use an irrevocable trust. And if you want to help your parents procure government benefits, you have to create an irrevocable trust for them so they can qualify for Medicaid. The idea here is that the government or the IRS or your creditors, you're given some benefit if you give up some level of control, and if you are not both the trustee and the beneficiary. So what does that mean? These are the parties to an irrevocable trust. You can create it. Now, you can either be the trustee, meaning the person who's in control of it, or you can be the beneficiary, but you can't be both the beneficiary and the trustee because the court's going to say, what's stopping you, trustee, from writing out a check to yourself as beneficiary? Invalid. We're going to get the money anyway. So then you're messed up for creditor purposes, you're messed up for estate tax purposes, and you're messed up to try to qualify for things like government benefits like Medicaid. You have to have it in an irrevocable trust, and you have to be either the trustee or the beneficiary, not both. This is what it means to fund trusts. You know, if I have a bank account in my name when I die, it doesn't do any good. It has to be owned by my trust for it to be effective. You must name your trust as the current owner or future beneficiary. So my bank or brokerage account, it's going to be named after the owner is the Daniel Timins Trust, revocable trust. I can still use the ATM machine. It's not a big deal. Anything that pays out in the future, like life insurance or my retirement plan, because you saw I take distributions from it, the beneficiary has to be my trust. You know, sometimes you want life insurance owned by trust. That's a step beyond what we're doing today. Retirement plans, your trust can never own it until you distribute money from the retirement plan. So you change the beneficiary to the trust. Now, the benefit here of trust is also that they can avoid your beneficiary's creditor claims and personal problems. So like I said, with the trust, if your beneficiary has creditor issues or is getting divorced, a trust can save them. They have substance abuse provisions. The trust can say, you get none of this money. If there are marital requirements, you can state, I don't really trust your choice in husband or wife. If you don't get a prenup or postnup, you're not trustee of your trust, so I'm going to protect you from any potential divorce or anything like that. You can also state when you want to leave money using a trust. This is the plain vanilla. Attorneys laugh at this because every estate attorney does this. When you're 25, your child will get 1/4, 1/4. When they're 30, they get another quarter of the trust. And at 35, they get the rest of the trust, 25, 30, and 35. That's kind of like the easy out for most estate attorneys, because when people say, well, I don't know when I want to give it, that's when we say you should give it. Now, you have to name the right trustee. They do get paid a commission. I tend to tell people if they have a trusted family member, name that family member. If they don't have a trusted family member, name a friend who's a good friend who's good at this stuff. Or you can hire a bank or your attorney or a trust company or your accountant, etc. I usually tell people, you know what, you probably want to name the first two first because you know, the other people charge a lot. Last but not least, we're going to talk really briefly about unforeseen problems. You know, there's no hit like the one you don't see coming. You ever look at someone like Bo Jackson? He got hit by someone when he was playing football, and it didn't look like a bad hit. He didn't see it coming, and it messed up his career. This is the stuff that I see when people have horror stories about estates. It's usually stuff that they could have avoided. So here's one problem a lot of people have. They don't have any money left over when they die to handle their burials and other final costs and costs to attorneys. Remember, if I do create an trust for account, it's no longer in my name. It goes to my beneficiary, and they could say, I'm just going to keep it. You know, that's kind of a jerky thing to do, because if they paid for the attorney in the funeral and there is a probate, they'll get paid back. But technically, the money becomes that person's money. So you get stuck because you have this money that's waiting in probate that you can't get to because you haven't probated your estate yet. So you leave money as a transfer on death to your trusted family member who's now saying, yeah, I need the money instead right now instead of paying for Uncle Murray's funeral. You got a problem there. The way around this is by prepaying for cemetery plots and pre-funding your funeral. That way, you know everything will get done. Now, if you're 40 years old, you don't have to worry about this. If you're 60, you don't either. If you know someone who's 80, or if you have parents who are 80 or above, I want you to tell them maybe you guys should pre-fund your burial expenses so you know how much you want spent on it. Because otherwise, I'll spend way too much money on it, and you don't want that. And they're going to say, of course not. I want you to get all the money. If it's an aunt or an uncle, I can't promise they're going to tell you that. All right. I have people who leave money to minors or disabled individuals. That's a mistake. It gets them booted off of Medicaid. If they're disabled or if they're minors, they can't receive the property. The court needs to do guardianship because now a minor has all this money. You can use things like an UTMA account, which is Uniform Transfer to Minors Act account. I discussed that last week. I'm not big on them. Or you can leave it in trust. The big thing is if someone is receiving Medicaid benefits because they're disabled, you have to leave it in a supplemental needs trust. Cannot give it to them outright because these are programs that are created for people who are impoverished. If you leave it to them outright, they're no longer impoverished. It's got to go in trust. Here's another thing, trouble finding documents or beneficiaries. You know, if you take your documents and you shove them into your safe deposit box and no one knows about the safe deposit box, I got news for you. Those documents here aren't really worth a heck of a lot. You need to keep documents in a place that people can find them. Keep your will in a place where it can be found. If you're cutting people out of the will, maybe don't keep it at home. Those are the types of wills I hold on to. But find a safe place to keep your legal documents that other people will know about. And the other thing is family members. So let's say I'm not close with my sister and my wife passes away and then I die. I have no kids. So then my sister and my brother get put on notice. Well, my sister and I don't know her last address. You have a problem, it's going to add money to your estate. For people who want to create their own wills, I made these slides, we're not even going to go over them because you have legal insurance. Pay like the nominal fee that you have to pay to have an attorney or a law firm create your wills. I'm not even going to bother looking at this stuff. I know, do-it-yourselfers, it's usually not the document that gets you into trouble, it's the execution of the document. These are the important things. You need to make sure that there is the next of kin that are named in there, executors, witnesses. You want to have a file of the people that you work with as professionals, like your accountant or your attorney. And you can create a list of these people and where they can be reached and leave it with a few trusted individuals. I know we were rushed the last few minutes. I don't encourage people to do it yourself because then they have to find people like me to fix it up at the back end if possible. People like me then get paid about 5 times as much as we would have if you've done it right up front. And the way you can do it right up front is by contacting us here at Timmin Law Group. My name is Dan Timins, and I'm opening up the floor for questions after a rather frantic but I hope informative session.
Okay, thank you, Daniel. That was definitely informative. If anybody has any questions, feel free to type those into the chat box, and I'll go ahead and go through them. We do have a couple so far. The first one, and I'm going to assume this is what is being asked. The question is, do you need a will and a trust? And I'm going to assume that means, do you need a will and a trust together at the same time, or can you choose one or the other?
Great question. In a perfect world, everyone has a trust that is fully funded and it has all of its current property owned by the trust and all future things like life insurance proceeds with the beneficiary form named as the trust. In a perfect world, everything is in and goes to the trust. We live in an imperfect world where there are sometimes double E bonds or like an old stock certificate that's found under a bed that we didn't know about and we couldn't account for. I always suggest you also have a will, even if it's a pour over will that just says, if we need to probate this because it wasn't named after my trust, just dump it into the trust. That is called a pour over will. But I would suggest that having just a trust is not enough. You can have just a will, but then you have to go through probate for any property you own. The idea of having a trust is to minimize or avoid probate. If you have a trust, you should also have a will.
Okay, and that was kind of, it led into the next question, which was, is there a certain circumstance that you would recommend having one over the other?
I would definitely say that there's no good reason to have a will and no trust unless you don't want to pay the money and put the time into funding the trust. Someone like me charges a few $1,000s for trust for typical clients, not like 20,000, but a few. And some people get gun shy on that, believe me. if you are trying to disinherit someone, or you have hard to find family members, or you have family members outside the country, for probate, those family members have to actually go to a notary in a U.S. embassy or consulate to sign off and say, I approve of this will. A trust avoids all of those things. So if there is going to be some complication, if you have family members outside the country, if you have complex property, or if you have a very complex scheme for estate purposes, I would say you always want to trust over a will. Remember, you may not leave that much by your will, though, no matter what. If you have joint accounts, transfer on death accounts, retirement plans, and life insurance with proper beneficiaries, you may not transfer that much by your will anyway.
Okay, thank you for that. The next one is if I have a will at my home and it's destroyed, in a flood or a fire or something, some unnatural circumstance, do I have to redo the will completely?
Well,
Or,
I have good news and I have bad news for you. The good news is that most wills are now created on word processor documents. So your attorney probably still has that original draft. You just have to change the dates if you don't want to change the document, or you can change the document with them. The downside is that people retire all the time and their electronic files don't necessarily get transferred to their successor. The sad answer is yes, you will have to most likely redo that will. Now, I've seen wills that have come in with coffee stains and dirt on them, so that's okay. But if it's completely wrecked, you're going to have to do it over.
and I guess I would recommend to everyone to go ahead and scan it, have an electronic copy of it as well, just so
Yeah,
you can reference and
yeah,
remember what decisions you made.
yeah, that's probably helpful. Really with the will, you probably don't want to be looking at it every 2 or 3 days. Action Comics, the first appearance of Superman, you don't see the owner of that. You can't imagine him taking that out of its carrying case and like looking and reading it every few weeks, because then it'll just start getting ruined. So then scanning a copy is probably fine. But remember, you really need that original too.
Okay, and we have two more quick questions. Do life estate deeds carry over from state to state if the owner of the home with the deed resides in another state but still owns the other property?
Well,
Um,
I'll see if I can understand it. So let's say that I have a parent who owns a house in Connecticut, and they say, I leave it to my child, but retain a life estate. And then they move to New York or New Jersey, then it's still a valid life estate deed. If, however, they sell that property and then they buy a new piece of property in the new state, then the answer is, of course, no. The deed change has to be made every time there's a piece of real estate that's purchased or sold.
okay, thank you. That did answer that. And the last question is, this person has an unmarried adult daughter with no will, and they've heard that they should at least get her set up with a medical power of attorney so if there's any medical issue, they can be involved because she's unmarried, not with anybody, no other children. That be your recommendation, medical proxy or power of attorney in
Perfect.
that case?
I have three. Power of attorney, you're correct. Healthcare proxy, thank you, listener, you are correct. And number three is make sure that that child's bank accounts name the parent as a transfer on death or in trust for beneficiary, because there's no need to have to do a small estate proceeding. If there's $3,000 or $4,000 in a bank account, it almost adds insult to what's already an injury. Name yourselves as a transfer on death beneficiary on that kid's bank account. And that's all they need.
Okay, thank you for that. And thanks, everybody. I know we went a little bit over, but Daniel, I appreciate your time and all the information that we've learned in the past 2 weeks has been very valuable, and we appreciate it.
Thank you so much. Good luck, everybody. And I look forward to any questions you may have. Give us a ring.
Great, thanks. And everybody, remember there's a handout attached, and you can get any contact information for Daniel if you like, or just, to have some notes from today's session as well. Thanks, everybody, and I hope you have a great weekend. Take care.